What is back to session? You may be seated.
22-117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make a verdict.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agree that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I ask you a question then. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Two different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the lesser included.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise to the court, please.
Welcome back to Fair and Square Files, everyone. We have a very quick update for you on today's proceedings in the ongoing trial. The jury deliberation is currently paused as they've finished for the day, but not without some noteworthy developments. Today in court, defence attorney Alan Jackson raised a significant concern regarding the verdict slips given to the jurors, specifically the placement of the not guilty boxes. This led to a tense exchange, but ultimately the judge agreed to change the forms after the prosecution did not oppose the modification. Jackson expressed his gratitude for the change, highlighting its importance for a fair deliberation process. Now, as for the jury, they have ceased deliberating for the day, but rest assured we will keep you informed as any information comes to hand, but I'm sure just like me you are glued to the screen at this present time. And as always, your insights and engagement are greatly appreciated. And if you haven't already, if you could hit that big red subscribe button, that would be so appreciated. We look forward to covering multiple other cases in the very near future with you. But for now, let's listen to the judge's reply.
Your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
May I have just a moment?
Yes.
Thank you, Your Honor. May I be heard?
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip that says the two words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense. That's it. And I think that and the court's clarifying instruction would satisfy the defense. That's all I think. I know it will. That's all we ask.
All right.
I can repeat that if the court wishes.
So there are some like minor changes we have to make to the verdict slip anyway. Just, you know, it has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
You want-
Not guilty of the offense charged or any lesser included offense.
All right, I think the clarifying language that I proposed is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I need to clean, I'd like to send in a written copy of what I just read. I have a couple of things bolded. I need to fix this up a little bit. I mean, it was just done quickly. The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that? I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just going to ask, do we have that emailed to us or something?
Yeah, we all need to see it. I will work with Tori. All right. All right, can we bring the jurors in, please? Oh, I'm sorry. What suggested language on the cert report?
I'm sorry, Judge.
Any suggested language on their question?
No, I think the court's correct that in terms of the cert report request, the court's answer is right on point, which is you are directed to you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything. Okay.